It's Justice Thursday. Every Thursday, we try to have a conversation about our justice system, how to promote social justice for economic prosperity. That's what we'll be discussing today. Our guest is in the studio. We have the Honorable Justice Dr. Jacob Gakeri, who is a judge of the Employment and Labor Relations Court, joining us in the Situation Room for this Justice Thursday conversation. Good morning, Judge.
Good morning.
Welcome to Kenya's biggest conversation. Welcome to the hot seat of the bigger bench.
Thank you. Thank you for having me.
Yeah. So this is a 3-judge bench city.
Not 3-bench judge. There are 3 judges sitting on a bench.
Yes.
Okay, that one I've got it.
Now that you've gotten.
Yes.
3-judge bench.
3 judge first, then bench.
Yes.
Not bench, then judge. Okay, got it.
Yes. Karibu sana, Judge.
Thank you.
City always has the day's proverb. I'll give it to you. Today's proverb.
Yes. Our proverbs for the whole of this week are from the country of Libya.
All right.
Now, Libya doesn't have the sort of structure of government that the rest of us are accustomed to. President, deputy, or vice president, and so forth. They have a chairman of the presidential council. And then they have a vice chairman of that same council. Then, to give it a civilian tinge, they have a prime minister. And of course, they have a speaker. All right?
Yeah.
Their chairman of the presidential council is called Mohammed Al-Menfi. Now, this country has had a civil war for the longest time, but it isn't the first one. They had an earlier civil war, but this one has now abated, so there's a semblance of stability in the country. Now, the proverb, like the sparrow, he wanted to imitate the pigeon's walk, but lost his own.
Like the sparrow, he wanted to imitate the pigeon's walk, but lost his own. Judge, when you hear that proverb, first of all, what comes to mind? Sparrow, imitating, pigeon's walk, losing his own.
It creates the impression of a person trying to do something that they are not able to do or they cannot do, but they are imagining they can do it. Yeah, so they end up making a fool of themselves.
So what message are they sending the Libyans? Avoid making a fool of yourself by copying others.
Oh, look at this sparrow. Should have been flying, and now it cannot walk. It's just hopping about.
When you try to imitate or follow what others are doing, you may move away or deviate from a path that you had set, which was advantageous to you. But in so following, even that path that you had set up on, you now lose.
You lose it completely.
Yes.
Nice one.
Yeah.
Judge, the Employment and Labor Relations Court, we have had several judges from your court.
Yes.
And we've talked about many issues of what, this court is. First of all, the conversion from the previous, labor and then the labor laws then now becoming a proper court with same jurisdiction as the High Court.
Sure.
And the work that you have and the workload. And every time we have these conversations, it's always about how many cases you're dealing with and how you are dealing with, basically just ensuring that there is justice delivered and in a fair manner. So let me just start with current status.
Yes.
In the current status of the court, what are the kind of cases, majority of the cases that you're handling? And how do the judges of the court then organize themselves to deal with them?
Thank you for that question. The majority of the cases that we are handling as of now are terminations of employment. That has always been the largest complement of disputes in our courts. And let me go backwards a bit. After the the establishment of the court as it is today, and of course, as guided by the Constitution of Kenya 2010, there was actually an avalanche of cases never witnessed before. Of course, previously the court was more of a tribunal, and not even many practitioners used to practice there, and its decisions were rare to come by. But when it became a proper court, and because of the new constitution and the provisions it created, people are energized and motivated to come to court. And that is what accounts for the large number of cases that we are seeing in court. And that has been the case. And we've been battling a backlog of very many cases. Actually, the first 12 judges who are appointed could not handle the workload. And that has spilled over. You'll be surprised that we are currently dealing with the cases of 2018. We still have very many of 2017, but now we are graduating to the 2018 disputes. So we still have to come to 2019, 2020, 2021, 2022. However, for those that have filed a certificate of urgency, they move faster because they relate to matters that require urgent determination. But we still have to deal with the backlog. Most of them, as I have stated, are essentially termination of employment. Yes.
What are these cases that would qualify for certificate of urgency?
Most of them come in by way of petition. Majority of them come by way of petition. A person has been terminated. It could be, and they want to be reinstated, or the termination has not occurred, and they want to have the termination restrained or injuncted, or a proposed redundancy, and courts are called upon to make a determination on the matter. General matters that require urgent resolution, all some cases of public interest where a spirited citizen decides to file a matter on a case that involves
like the recent
public
matter
matters.
of the chief administrative secretaries
Yes,
that had come before that. So that fell under public interest.
Yeah, it depends on who is bringing it. If it is bringing by an interested party or a party, one of the parties, then it is no longer public interest. But if it's an outsider, a member of the public, or an NGO, or an activist, then it's public interest.
Okay.
Yeah.
Why do they take so long, these cases? You speak of, cases of 2017 being currently in process. We're in 2023.
Yeah.
What is it the nature of these cases that makes it take so long? What is the reason why they take so long to adjudicate?
Honestly, it's not the nature of cases that occasions the delay. First, as I've indicated, we had the challenge of capacity. We also had a challenge of the geographical spread of the court. But with the appointment of the group through which I came in, sometimes in 2021, actually early June 2021, the number of judges has rose by 9. There's supposed to be 10. One of us, unfortunately, passed on before we were appointed. And that has really energized the judges who are there. That they worked very hard, but they were overwhelmed. Most of the cases are in Nairobi, of course. And we have devised strategies of reducing that backlog. One of the causes of the delays are adjournment. And the adjournment could be occasioned by, it could be the judges unwell. It happens. Judges are individuals,
Humans.
like every other. But a research has been done and conducted, and it has been ascertained that 60% of the cause of adjournments are lawyers. The lawyers are doing the matter. 60% is contributed by advocates. And one way of dealing with that is a policy of no adjournment.
Is it advocates
not being ready.
So it's not advocates under the instruction of the litigant
The clients.
or the clients.
Sometimes, see, that is the advocates and their clients are one party
So
when
you
they come
consider
to
them-
court.
Okay.
So the cause of delay could be the client or the advocate or both, because sometimes they don't appear. But that they contribute 68% only. The other causes. However, if a case is scheduled for hearing and the judge is before the court, it is supposed to go on. It ought to go on.
Regardless.
Yes,
Okay.
it ought to go on. And if the parties are not ready, they must give a very, very good reason. Otherwise, that case can be dismissed. Yes. Or proceed to the next level. If it's taking of evidence, the case is closed. The claimant's case is closed or the respondent's case is closed, and we go to the next stage of judgment.
Justice, we have to ask, what would be a good reason for adjournment?
The lawyer is indisposed and there is evidence that the person is indisposed. Sometimes they are in hospital. And you also look at whether the lawyer who is indisposed has communicated with the other counsel on the other side, so that counsel is aware that the matter will not be proceeding. That would be a good reason. Indisposition is a good reason. But saying that I have not communicated with my client or my client lives out of town, those are excuses, they are not reasons.
So is this a policy that the judiciary is going to put in place, or is it something
No, it's already there.
only
It's already there.
in the labor?
No adjournments. All courts
All courts.
are guided accordingly. No adjournments unless it is absolutely necessary.
So is it now a policy?
Well, it's a guideline.
It's a guideline.
That, yes, to ensure that cases move.
Okay.
Do not take adjournments unless, of course, they are inevitable.
Okay.
Yeah, there are cases where it is inevitable. But if the judge is there, because judges have course lists every day, as long as you are not on leave, you are not, even when you are unwell, unless it is something that is programmed, there's a course list. And there are cases to be heard.
Okay.
And sometimes there are many. And it is the duty of the judge to ensure that those cases are heard on that day. Because tomorrow, there's another one.
Yeah.
And the case will have to be heard.
Will have to be heard.
Yeah.
Before we go into the nature of some of these cases, and then you mentioned that, usually these cases will take their course in terms of time unless somebody files for adjudication under a certificate of urgency. Now, if a certificate of urgency can be filed, what does this mean exactly? That everything else that is before the court will wait while this is dealt with quickly? Do they pay a little bit more money? Do they stop the process so that their case can be heard? What happens when a certificate of urgency is filed for?
What happens is that the other case will continue, but this one is dealt with more urgently. Not that it's dealt with on the same day. No. It still has its own queue, but a shorter queue.
Okay.
Yes. To ensure that that urgent matter is resolved.
Okay.
Yes.
And it still could take a year. It still could take 6 months under a certificate of urgency?
You'll be surprised that even cases filed a certificate of urgency take even years. Because sometimes the case is filed, but the party that filed the case, for one reason or another, does not follow it up. Because it's still the duty of the party to ensure that the matter proceeds. Yes, and moves from this stage to the next stage.
Okay.
If they are given a date, they ought to appear. If there are directions given to be complied with, they ought to be complied with. But sometimes they are not complied with. Or the parties do not appear. Or the principal party, the one who filed the claim, the petitioner, does not follow it up. So they are still there of 2021, filed that certificate, 2019, courtesy of the parties.
Sure.
Why not dismiss them? Come up with just
Taking
basically
so
say, this matter was filed by Party X. Party X has not followed up. Hearing was scheduled for this day. Party X, who is the claimant, did not show up, so we dismiss the cases. And if Party X is still interested, file afresh and join the queue.
Actually, that's a strategy that a court uses, where the files are called up. Since 2021, it has been used, because if nothing happens towards furtherance of a matter and 1 year lapses, that law applies to all the courts. That matter is up for dismissal, but the court must give a notice. The court may, suo motu on its own motion, give a notice to show cause why the matter should not be dismissed. And matters have been dismissed, and after some time, somebody files now a certificate again.
On the same matter.
On the same matter, that they want the matter instated. Of course, that matter does not qualify for a certificate, and it will queue like any other. But that necessitates them contacting the other party and the court making a ruling on whether the matter should remain dismissed as it is. Some of them are, say, of litigants, and the court is likely to be more sympathetic to such a person, now that they may not be well versed with the electronic filing system. And such matters move actually very fast after that, and they are concluded. But some of them are dismissed, and that's the end of the story.
In the case like that where you said, a litigant refiles a matter that has been dismissed, does the court then shift in terms of interest and interest of justice to the respondent? Because the respondent had gone through the entire motion of the case previously. Just sitting there with a case hanging over your head is big enough. And then now this matter has been reintroduced to court. And it could also just be probably because what the claimant is basically doing is making sure that there's that thing hanging over your head. It's just causing you distress. Does the court then shift and say, okay, come on, you have subjected this party to undue stress and distress. We are not going to allow this matter.
No, that is one of the main considerations the court takes into account when making the determination as to whether the matter should remain dismissed. Yeah, because prejudice to the other party is critical. You have your rights, but if you slept on them for too long, you're causing prejudice to the other party and should be penalized for that. So unless there's a very good reason, once a matter is dismissed, it ought to remain dismissed. But again, each case is decided on the basis of its own circumstances. This no the general rule, it ought to remain dismissed. But again, this person comes with reasons why, and sometimes they even provide letters showing that they wrote to the court seeking for a date, and one can see the trail. Until they kept pace, they tried their best from where they were to ensure the case proceeded. But for others, nothing. 1 year, 2 years. What reason can you give for 1 year? For 2 years? You've done nothing in furtherance of your matter. You filed it. Sometimes at the certificate. Yeah.
The last judge from the Employment and Labor Relations Court who was here was Justice Nzioki wa Makau. And he was telling us about what happened in the Judiciary Service Week, where the court decides, all right, we are going to have some rapid results initiative. We are going to accelerate hearing of matters and basically picking out cases that just we can dispense with quickly.
Yes.
And that week, the court then deals with very many cases that go. Why wait for the Justice Service Week? Why not just decide we are going to have an RRI month to look at all, by the time we are done with this month, all matters beyond 2018 will have been sorted. And we get into, because I can imagine, I don't know, I'm sure you have the statistics, that COVID period of 2020, 2021, there may be very many cases that have been filed because of what happened in the labor sector.
Sure. The service week helps, but one of the challenges is that it has its financial implications, because service week means bringing judges from the outstations, to Nairobi, and you have to take care of that. If it was possible financially to do it regularly, then it's a good way of ensuring that the busy stations like Nairobi, where we have so many cases, are assisted by the judges from the outstations. But it's, for the most part, I think since we joined, we have undertaken that exercise only once. That is 2 years ago. Okay. Could be previously it was more common, but at the moment it's not as common. And then 1 week is very short to do it. If it was possible 2 weeks, that would make a very, very huge difference.
Or a month.
Because there are many, a month is maybe too long, because there are cases in the other stations that also require attention of the same judge who is in Nairobi.
Okay.
What sort of cases would you consider as urgent?
Redundancies are, there are some actually that are provided for by the law, like matters involving unions. The Labor Relations Act provides for that expressly. They have their timeline to ensure that there is industrial harmony. These others depend on the circumstances of the case. What is the dispute here? Like the CS's case, which came in, I think, last year. Yeah, that was an urgent one because it affects a state function. Yeah.
Our guest is the Honorable Justice Dr. Jacob Gakeri from the Employment and Labor Relations Court on this Justice Thursday, talking about the matters that they're dealing with in this court. So you all acknowledge as judges of the Employment and Labor Relations Court that you are dealing with a serious backlog that dates back 5 years. So what's your plan?
The plan is to ensure that we reduce those cases that are more than 3 years first, as well as deal with those that are urgent. And that is something we have done continuously for the last several years, and we've seen results. So the backlog is coming down, though a bit slowly here in Nairobi. In the other outstations, it's faster because the rate at which they clear the cases and others are filed is lesser than here in Nairobi. But because we are more here, actually from early this year, we are 12 judges in Nairobi now, from 10. And the two HUDs have made a huge difference in the clearance rate of cases. Still slower because of the nature of cases that we handle. Sometimes there are heavy petitions that are filed in Nairobi and not filed elsewhere. But we are making good progress in the clearance of cases. It's just a matter of time, and we'll reduce that backlog to a bare minimum.
Okay.
Yeah.
For looking at the nature of the cases that you spoke of, dealing with things like terminations, and then saying that also because of certain factors, these cases may take time. Do you deal with the issue of statute of limitations within this court on all these cases?
Yeah, we do. Actually, our act, the Employment Act, is very clear on the limitation duration, which is 3 years. In other cases, it's 5 years. But the Limitation of Actions Act, there are different durations for the various types of cases. But for employment matters filed under that act, it is 3 years. So after 3 years, the prospective litigant loses the right to enforce the claims under that act. And we see cases, not too often actually, but there are cases that are dismissed on that basis. Yeah. Of course, sometimes, strangely, sometimes the lawyer on the other side may not notice. But most of the lawyers are very keen and they notice that the matter has been overtaken by time. And the court may, on its own motion, dismiss the matter. Because at that point, after 3 years, the court has no jurisdiction to hear and determine that dispute. Yeah.
Okay.
So it's not a major way of reducing the backlog because it's rare, but it does happen.
It does occur.
Yeah.
So now, can we look at the nature of some of these cases that are presented to the court?
Sure.
You've talked about them being terminations. So who in excess, or rather, if we look at percentages here, the litigants, would they be folks who then have been wrongfully terminated, or at least that would be their case that they brought forward? Who are we looking at that's bringing cases before court?
The majority of cases are obviously brought by the persons who have been terminated by the employer. But it's important to underscore the fact that there are various ways in which an employment relationship or contract may be brought to an end. The parties can agree that we can have what is called a bilateral termination, where parties sit and agree to bring that relationship to an end. That would be the best if it worked. Although they are a bit rare The bilateral ones are a bit rare. The most common are unilateral, which is giving of notice. The employee gives notice or the employer gives notice. Those are common. Then we have those that are enforced by the employer, mostly, because if the employee gives notice or the employer gives notice, they're supposed to ensure that they comply with the requirements of the terms of engagement, the contract itself. If it's 1 month, it's 1 month. If it's 3 months, you have to give 3 months.
And you serve the 3 months.
Yes, and you serve all, the parties could agree. It could be you have leave for 3 months. Then parties agree it will be catered, the notice will be catered for by the leave or any other arrangement. But sometimes notice is given and you say, my resignation is immediate. I want to leave now. Yeah. That is ignoring the provisions of the contract you signed. So at that point, you're supposed to pay then the other person the salary for 1 month. That's agreed. Yeah, because that is salary in lieu of notice. Otherwise, employers also do it sometimes. They say you are leaving today.
Yep.
Yeah.
Many times.
Yeah. And they not even, most employers pay the notice. But if I'm told to leave today, it means there are certain provisions of the law that will not have been complied with, which are very, very important. And that is one of the reasons why we have the backlog, where the law is not complied with, mostly by the employer. Yeah. Of course, that is based on the history, where before the new dispensation, remaining in employment was at the will of the employer. Yeah. But that has changed fundamentally at our constitution and the law.
So currently you have to go through a process before you make that determination that you are being summarily dismissed.
Yes.
You cannot just wake up and summarily dismiss somebody.
Well,
what's the process?
It can be. It's possible. It's provided for by the law, actually. Section 44 of the Employment Act provides for that. But even then, whatever the employee has done, they should be told, this is what you did. We want to hear from you.
Right.
Yes. Tell us your side of the story. It can be. It ought to be in writing in the first place, so that the employee has a chance of responding in writing.
Right.
Let them say something about what happened, and then if the explanation is not satisfactory, call them for a meeting, so that we'll subject you to a disciplinary hearing on this particular day.
Right.
And these are the allegations. If they want any documents, give them the documents. Yeah. No matter how short the notice is, but it ought to be reasonable. 3-4 days should be enough for the employee to prepare. And then let him come and respond to the charges or the allegations. And there ought to be minutes of what transpired.
And it doesn't matter the level of employment.
No, it doesn't matter.
Whether
it does,
it's
from the managing director or the CEO to
domestic
the cleaner.
work.
Yes, to the cleaner.
And is there a specific time within which this matter must be determined, concluded, and set aside?
Well, as quickly as possible is good, so that if there are any parties that are aggrieved, they can run to court. It's also good for the employer to get rid of such matters if there are allegations. So that taking the employee through the process will tell the employer whether they have a good ground to dismiss this employee or they do not have.
You see, for a situation where there's an employer and an employee, it's clearly a critical matter by the time even the subject of summary dismissal is being brought to the table. See, I'm looking at our electoral process and matters that go to the Supreme Court. Specific timelines. You're told you must do this by this time. Okay? Now, the ramifications of a dismissal are enormous.
Sure.
Because it's not just you were employed. There are many obligations that are attached to that salary. There are many things that will change literally overnight. Now, so as to limit or mitigate against all the harms that can come about as a result of this, I'm simply asking, you want it concluded in the fastest way possible, but does the law provide for a specific time, meaning 2 weeks, 3 weeks, a month, 2 months, things like that? No, it doesn't.
For many organizations, take care of the bigger organization, even small ones. Their HR instruments provide for the duration. I've seen 6 months, which is a bit long, because this is an employee who will remain on tenterhooks for the 6 months. The shorter it is, the better. I've come across a situation where I was working, where an employee was dismissed within a very short time. And all the processes were complied with, incidentally. There was a notice to show cause. The employee was invited for a hearing. There was a hearing by a duly
afternoon.
But not that afternoon. After some time, by a duly constituted committee, where she was still in employment, and eventually a decision was made that she had to leave. Surprisingly, that employee, who was actually a good employee, in my view, because she was in my department, did not go to court, and she would have won the case.
Why?
The disciplinary committee did not find her culpable.
I see.
Yes.
So she was asked to show cause. She sat before this committee. Basically, the committee was investigating the allegations against her.
Yes.
And in her response, they did not find anything to counter what she had presented as response.
So
what were her grounds for then termination? What were the grounds that the committee used to?
I was a witness myself in that. Before that committee, I was invited, and she explained what happened, and it was clear that she had acted in good faith, whatever happened, and no one's interests were prejudiced. But I think there was some enthusiastic person who didn't like it. It was a sad case, a very sad case, because she was a very good employee, very good,
dedicated.
But yes, she was.
But then you end up, just because somebody damu yake haikupendi, you have to go.
That's what happened. Some of us could not do anything. I was head of department. I couldn't do anything. It was above me, so she
left. So if such an employee goes to court and they file unfair dismissal, right? What are they likely to get?
No, if you file the case very quickly, it is determined within 3 years. There's a remedy of reinstatement.
Okay.
You get back your job.
Okay.
Because there was no reason. The procedure was followed. That's why some of us appeared even as a witness. But there was no reason. One of the requirements for a lawful termination is the employer must demonstrate that they had a valid and fair reason to terminate that employment. Valid and fair. Then we go to the next, the procedure. The procedure is just the way it is done. But the more critical thing is, was there a reason?
May I ask,
yes,
what prevailing circumstances then the bench would take into consideration when making that? Because if we're, in this case particularly, if you're saying that somebody just had it out for this person, right, because they didn't, they didn't jive or whatever, this person then loses her job. And then she goes to court. Within 3 years, this case is determined and says, okay, we're going to reinstate you back into a situation where there's already some kind of bile. What is considered when making that determination? Because, we're often told that judgments will take on that persona, taking into consideration the atmosphere around a particular case. And so here is an individual who was unliked by someone else, and that is what resulted in this initial termination. And then you're saying, go back to that same situation. We are going to reinstate you. And you as an organization have no choice but to bring her back. What do you do? Would you not consider that?
One of the considerations that the law actually provides, the parameters the court is supposed to consider. Actually, very many of them, to the extent that they are relevant to that case under the Employment Act. One of the things the court considers is practicality of that. What's the practicality? Yeah. What's the duration? is the job still there? Has somebody else been hired to occupy your position? So the court would, on the basis of all those circumstances, determine, should you be reinstated or should you be compensated?
Okay.
Yeah.
And what if you are reinstated? Do you have a choice to determine whether you do not want to go into that same ecosystem, but you'd rather be compensated? Does the person whose contract was terminated have a say in this matter?
Yes.
Okay.
Yes. You can tell the court, I don't want to go back there. Although you applied for reinstatement, you can as well tell the court, I think the better option for me is not to go back there. Yeah.
Does somebody who brings a case before court have to be represented by an advocate, or can you come on your own and self-defend?
No, the answer is no. One of the things that the new constitution brought in, which is very important and which is reflected in our law now, is simplicity. Simplicity of matters, particularly those dealing with employment and labor relations. It's very easy there, though, even though the cost of filing a suit is nominal to accommodate the common person. And many people have filed cases individually. Yeah.
Okay.
And they have prepared their own documents. Of course, it's good to, if financially able to have a lawyer, but all of us as judges have decided cases initiated and and prosecuted up to conclusion by a former employee.
Okay.
Yeah.
We do have some questions that are coming from folks, and I think it's interesting.
Sure.
One of them, Martha asks, you speak of summary dismissal. What if you want an employee out? This is now from an employer's point of view.
Yes.
What if you want an employee out and you wait for their contract to end and don't renew? Is this fine, or do you also have to explain and take the person through the process? Because this person could come around and say, well, you just waited for my contract to end and then you got rid of me.
No, the answer is no. For what we call fixed term contracts, a fixed term contract is a good contract where the duration is fixed. Begins at point A, ends at point B. And it lapses on its own by a fraction of time. However, for some employers, which is actually bring about very many disputes, is where we say subject to renewal.
Yeah.
It's renewal subject to performance or doing something else. That's where the problem starts and begins. If a proper fixed term contract should be, it is for 2 years, non-renewable. If after that the parties decide to enter into another contract, they may do so consensually. Yeah. But the moment you say it is renewable, subject to something, that creates some expectation. Actually, a legitimate expectation. I've been performing well, so I expect a renewal.
Yeah.
If you don't renew, they come to court. Some employers even go beyond that and make it worse. They don't renew, but the person remains in employment and they are paid.
Oh, so they are still in employment.
Yes, they are still in employment.
Contract expired in March.
Yes.
We are in July.
Yes.
We have not had a conversation.
Yes.
You've been coming to work. You've been getting paid every end of the month.
Yes.
April, May, June.
What does that mean? That I'm still employed?
Yes, that is still employed.
So what would the interpretation of the court here be? That this contract was renewed because there was no conversation about non-renewal?
The court will not deem it renewed. Yeah. Because it was not. It was renewed.
Because there's nothing in writing
Yes.
that indicates it was renewed.
That contract was not renewed. But, see, the employer is tying himself or herself or itself by continuing to retain this person and paying them. So if they want to dismiss the person, if they pay them per month, they must give a 1 month notice.
Okay.
And tell the person why they are dismissing the person.
So are you saying that courts recognize the term local arrangement?
In employment, there cannot be a term local arrangement. If an employee is rendering services and they are being paid, they are in employment. Remember, the contract of employment does not have to be in writing.
So the
Can be
process,
oral. Yes. The law provides for
or
contracts.
even if it isn't oral, but you continue in service doing what you are doing and you're being paid, that entire process
Yes.
equals employment.
Yes, it is. It shows that the person was working. Because they'll come with a payslip, which the employer is supposed to provide. Legally, they are supposed to. Even where they don't, they're supposed to provide a payslip, itemized payment, showing this was a basic salary, the house allowance, other allowances, deductions. Yes.
There are cases where an employer decides to declare a position redundant, so to get rid of an employee. Now, if then the employee comes to court and says, my position was declared redundant, as a host of the Situation Room, but I have seen they've hired somebody who has come in as a host of the Situation Room. How do you deal with that?
Or how do you interpret redundancy?
Yes.
Well, actually, the law provides for redundancy from the definition all the way to the requirements.
Right.
Section 2 and Section 40 of the Employment Act. There's a process, but let me say, analogous to other contracts, for every termination to pass muster or to pass the fairness test, there has to be a reason that is valid and fair, and there has to be a process. Even for redundancy, the same. The law requires a justification for redundancy, whether it is technological changes, whether it is the overemployment, downsizing, whatever terms are used. There has to be a justification for that. If the law is not complied with, there is no justification, or the procedure is not followed as prescribed by law, then that is an unlawful termination.
Interesting.
It graduates from a redundancy to an unlawful termination.
So
Yes.
is the individual declared redundant, or is the position declared redundant? And if an individual is declared redundant, or rather if a position is declared redundant, and in the next month an individual has filled that position, can this individual then come to court? Because you've said, look, this position has been declared redundant. Why do you have somebody else
No, it was
working there?
reopened.
And it was reopened for somebody else.
Yes, that is what will amount to an unfair termination of employment.
Okay.
Yes,
But
that's unfair termination.
An employer can just play games.
Yeah, of course they do.
Reason is downsizing and right-sizing because my overheads are high. So this particular position was attracting a salary of 100,000 shillings. I've declared it redundant. Then I create a new position that has similar
But not
scope,
quite.
but not quite. And this new position is earning 98,000 shillings. And I recruit somebody to fill that position. Can you go to court and say that position
Yes.
has been filled?
Can you?
Well,
not the
depends
same.
on the evidence that you have. Yes, to show that in fact that is the same position.
It's the
person
same
is
job.
doing the same job. Yeah, but you see, generally speaking, is that you cannot declare positions redundant, and then you are hiring. Whatever
can't.
reason. Yes.
It's like it's a contradiction, isn't it?
Yeah. It is. It shows that there was no redundancy in the first place. That's what you have called playing games. Employers do that. Of course. But where the employee has evidence to show that that's exactly what happened, courts will ensure that justice is administered.
You can actually go back and you can take that matter to court.
Yes. Because they may have complied with all the requirements of the law.
Yeah.
But that's an unlawful termination.
Wow. There are very many things that we keep learning. Every time we have a judge from the Employment and Labor Relations Court, we learn things and new things. Why is it that this information is not out there? Who has the responsibility of ensuring that people understand the Employment Act?
We do. Kenya law does. That is National Council for Law Reporting, which actually is doing a very good job in terms of ensuring that the laws are accessible, and they are accessible today. We can do it even through the phone. All the laws are accessible, but that is the statutory law, and one can even download all those laws and at no cost. Yeah, whatever the statute we want. But we also have open days. They may not be very common, but they do. Right now, this one of this appearance today is part of the build-up towards a celebration of 11 years, not 10. It was 10 last year. Now it will be 11 years from 17th to 21st at the KICC.
Right.
And there will be an exhibition, and members of the public are welcome.
17th to 21st.
Yes, 17th to 21st at KICC.
Celebrating the
We also have
Employment and Labor Relations Court.
a webinar on 14th at 3 p.m. on the digital workspace,
Right.
which is an academic discourse.
Judge,
Yes.
we have had a good time with you. Thank you very much for joining us.
This is the Situation Room, the only way to start your day.